of another party. So we have muted you, ma'am, because obviously you weren't going to stop talking. And this matter is before the court pursuant to the plaintiff's motion to enforce parenting time order. And court will note Mr. Kelly.
I think this may be Athena. Judge, let me call the case.
Okay.
Calling case 2024-1372 DC, Zachary Conley versus Athena Couch. Today is Monday, January 27, 2025 at 9:15 a.m.
Okay. Court will note, as stated, Mr. Kelly, on behalf of the plaintiff, this is plaintiff's motion to enforce parenting time order. And you are Ms. Couch, is that correct? You can unmute. You have to unmute your phone. Ms. Couch?
There, did you unmute me? Yes. Yes.
Okay. Go ahead, Mr. Kelly.
Your Honor, this is the third time we've had to file a motion with this court for my client to get parenting time with his kids. We're dealing with the same allegations.
Children.
Hold on one second.
Parenting time to my
Ms. Couch, Ms. Couch,
I got heart problems. Or I would have been in the courtroom when this happened.
Mute her again.
Yes.
Ms. Couch, whoever is the other person, it's your mother, tell her to be quiet. She's not a part of these proceedings. And I don't want to hear from her again. If you want to be heard, I'll listen to you. I'm not listening to her. Okay, go ahead, Mr. Kelly.
Your Honor, again, this is the third time we've had to file a motion for him to see his kids. These are the same allegations she's brought up that were investigated by the Department of Health and Human Services and denied. I believe she even contacted CPS again. They didn't even investigate this time. My client hasn't been contacted. It's been over a month since he's seen his children. He dropped them off in compliance with the court's order on December 23rd so she could have Christmas Eve. He came there on December 24th to pick the children up. She refused to turn the children over. He contacted the police. She closed the door on police, simply refusing to turn the children over. So we're requesting, as to the holiday parenting time, Your Honor, he didn't get the children back till the afternoon of Christmas Day, when he was supposed to have them Christmas Eve at 9 p.m. until through the following day. We're requesting for 2025 that he be awarded Christmas Eve and Christmas Day to make up for those holidays. He went back for his regularly scheduled parenting time in January. She refused to turn the children over. And he hasn't seen him since. When he shows up for his parenting time, she either will refuse to comply or she'll leave and just not be present at her home. We are requesting then, Your Honor, for his makeup parenting time that he get the children this Wednesday, January 29th, and that he be allowed to keep them through to February 9th, which would cover all the days he's missed for his parenting time. We would also request another $500 in attorney's fees. That would be $1,000 that would be outstanding because she's still not paid the $500 from November 1st order. We're not sure if he has a child support arrearage. I don't think he does. We'd request flexibility from the court. If it is indeed determined that he has a child support arrearage, that he be allowed to apply those fees to credit. If for whatever reason it's determined he does not have any arrearage, that attorney's fee bill be paid within 30 days of today or the date of the entry of the order in this matter. Your Honor, we're also requesting that defendant spend this upcoming weekend in jail. She just doesn't get it. She thinks your court order is a suggestion and she's simply not going to follow it. And I have a feeling we're going to be back here again, but I think the next time we'll simply file a motion to change custody. We'd also request, Your Honor, moving forward. We'd request, Your Honor, moving forward, that for each parenting time visit he misses moving forward, that she withholds the children, that she spend a corresponding day in jail. Maybe that will help her understand that your court orders are to be followed. Finally, Your Honor, Your Honor,
Couch, do not interrupt. He is speaking. Do not interrupt, ma'am.
Excuse me?
Do not interrupt the attorney. He is speaking. You'll have your opportunity to speak.
Some fucking attorney.
Mute, Miss Couch. Okay, go ahead.
Lastly, Your Honor, we're requesting for his pickup this Wednesday, that if he goes there and she does not make the children available, that we would be able to contact the court to get a bench warrant issued for her arrest. Thank you.
Okay, thank you. Now we'll unmute you, Miss Couch, and you can respond. Go ahead.
So other than the fact that we're at the police station because their father, Zachary, the plaintiff, has been arresting them. I have a.
Has that been investigated by DHHS?
I do have a officer's number here, with a case number. It has not been investigated yet. No.
Have you contacted Child Protective Services?
You know what? I did contact them before when he was watching children, peeing and pooping and having enemas done on them. Yeah, I did contact them. And, they didn't do shit. And they're being molested. They were touched.
Ma'am, this is a court proceeding. Do not swear. We do not want vulgar language in the court.
He's molesting children.
Ma'am, then you have a recourse.
What is wrong with you people?
You can contact CPS or you can contact the police and have an investigation. That's what your recourse is at this point. Okay?
Okay. Perfect.
Okay, what the court is going to do, mute Ms. Couch if you would. What the court is going to do at this point is the court is going to order that there would be makeup parenting time that would occur for the Christmas that was missed, or Christmas Eve, that the plaintiff would have Christmas Eve and Christmas Day in 2025. That in fact he would be entitled to have the kids from January 29th, 2025 through February 9th, 2025 for makeup parenting time. The court would assess an additional $500 in attorney fees, bringing the total to $1,000, which would be paid within 30 days of entry of the within order in this matter. So that will be the order of the court. You can prepare that order, Mr. Kelly, submit it under a 7-day notice of entry.
Wait, I have a question. What is wrong? Why would you give children to somebody who's going to hurt them?
Mute Miss Couch.
Your Honor, in the event he goes to pick the children up on the 29th, we're getting from her, she's probably not going to comply.
Well, I'm not going to speculate as to whether she comply. I would think probably based on her response, not, but we'll address that if it happens.
Okay.
Of course not. He's arresting my kids.
Okay, the hearing is over.
Why? Why is the hearing over? Why is the
mute Miss Couch? Why does she keep coming back in if we mute her?
She's unmuting herself.
Well,
I removed her from the hearing.
Okay. You're free to go. Have a good day.
Thank you, Your Honor.
I thought that they kept muted until we unmuted them.
I can modify our settings to.
Yeah, I do not want somebody being able to unmute themselves.
What you just witnessed wasn't just a messy bond hearing. It was a slow motion collapse of trust, responsibility, and patience, all playing out in real time. Mr. Wyoff walked into that courtroom believing one thing, that his lawyer, the man he paid with what he claims was his last dollar, would be standing beside him. Instead, he was standing alone, blindsided, angry, and convinced the system had just set him up to fail. From the very first exchange, the tension is thick. Wyoff isn't confused in a quiet, nervous way. He's openly frustrated. I paid him, he keeps repeating. He didn't tell me nothing. He didn't tell my people nothing. To Wyoff, this isn't a legal technicality. This is betrayal. In his mind, he did what the system told him to do. Hire a lawyer. Trust that lawyer. Follow instructions. And now he's being told that attorney quietly withdrew the day before court without so much as a phone call. That's not just embarrassing, that's terrifying. Especially when you're facing a felony, sitting in custody, and hearing the word warrant come up more than once. The judge, however, isn't reacting emotionally. She's focused on structure, history, and risk. And that's where Wyoff's story starts to crack under pressure. The court points out something important. Wyoff hasn't been seen in quite a while. That's not an accusation, it's a fact on the record. From the bench's perspective, this isn't a man who simply missed one date because of confusion. This is someone whose presence has been inconsistent enough to raise red flags. Then comes the part that really changes the tone, the bond and conditions discussion. Because while Wyoff is focused on his missing lawyer, the court is focused on public safety and compliance. There are no active conditions right now, not because the court went easy on him, but because the warrant effectively wiped the slate clean. And the judge isn't about to let that vacuum sit there unchecked. No drugs, no alcohol. I'm going to test you like crazy. That line isn't personal, it's preventative. The judge makes it very clear, this isn't new behaviour. She's been testing him since the beginning, and she's not stopping now. Whatever sympathy Wyoff might be hoping for doesn't override the court's duty to monitor risk. Wyoff, though, isn't ready to move on. He wants to talk about the case. He wants answers. More importantly, he wants his lawyer, not a new one, not a temporary one, not an appointed one. The man he paid. And here's where courtroom psychology really kicks in. Wyoff explains what he believes caused all of this: conflicting court instructions. According to him, felony court told him not to come to this court. He followed that advice, and as a result, this judge issued a warrant. In Wyoff's mind, that wasn't defiance. That was obedience gone wrong. But courts don't operate on hallway instructions and verbal advice. They operate on written orders, dockets, and official notices. And when those don't line up, the burden usually falls on the defendant to clarify, not assume. The judge doesn't immediately accuse him of lying. Instead, she does something far more strategic. She pauses the process and forces accountability. She offers to bring the missing attorney into the courtroom. Not next month, not someday, early next week. That's a power move. By resetting the hearing to Monday, the judge shifts the pressure where it belongs. If the attorney truly abandoned his client without notice, he'll have to answer for it. And if Wyoff's story doesn't hold up, that will become clear too, on the record, in open court. Still, Wyoff can't shake the feeling that everyone is working together. That suspicion, the belief that the system is aligned against you, is incredibly common in moments like this. When communication breaks down, distrust fills the gap. And once that distrust takes hold, every procedural decision starts to feel personal. But the reality is this: the judge didn't revoke bond out of spite. She didn't impose conditions out of anger. She didn't silence Wyoff or rush him out of the courtroom. Instead, she froze the situation, set firm boundaries, and created a short timeline to force clarity. That's not chaos. That's control. Now, the real question isn't just whether Wyoff was misled. It's whether he took responsibility when things started to go off the rails. Did he verify his court dates? Did he follow up in writing? Did he contact the court when his lawyer went silent? Or did he wait, assume, and hope it would sort itself out? Because hope isn't a legal strategy. By the end of the hearing, nothing is resolved. And that's intentional. The judge puts the decision on hold, resets the case, and makes it clear that this situation will be addressed head-on, with all parties present. No more disappearing acts. No more second-hand explanations. So now it's your turn to weigh in. If you were sitting on that bench, would you believe Wyoff's explanation about conflicting court orders? Or would you see a pattern of missed responsibility masked by frustration? Was this a lawyer who truly failed his client? Or a defendant who relied too heavily on assumptions? Comment below, Team Wyoff or Team Gagliardi. And if this case opened your eyes to how quickly things can spiral when communication breaks down in court, hit like, subscribe, and share this with someone who thinks court is just about guilt or innocence. Because as you've just seen, sometimes the real battle is about trust and who pays the price when it disappears.